When I'm questioning a doctor in a medical malpractice case in a deposition, can the doctor's attorney go ahead and object and yell out objection for every single question that I ask? You want to know the answer? Come join me on this walk through the neighborhood as I tell you the exact answer. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is yes. The attorney could go ahead and raise an objection to every single question that I ask. But here's the better question. Is it a smart move to do that? Should the attorney be doing that? Is it appropriate for the attorney to be doing that? In my opinion, the answer is no, no, and no. Let me tell you what I mean. When I go ahead and question a doctor in a medical malpractice deposition, my client has sued this doctor claiming that he was careless, causing her significant harm and injury. By this point, we have a medical expert who confirms each one of our claims and confirms that we have a valid basis for a case. Now, during the course of the lawsuit, my client has already been questioned by the attorney who represents the doctor. They've had a chance to learn from her exactly what her problems are, exactly what happened to her in her own words, and what injury she has now and into the future. Okay. Now, shortly after that, I will then have an opportunity to question the doctor in this question and answer session known as a deposition. Lawyers also call it an examination before trial. Now, you should know something. There's no judge there. There's no jury there when I question the doctor. This typically takes place in the attorney's office in his conference room. And in this instance, it was taking place by Zoom, virtually. But still, I have the opportunity to question the doctor, and my goal is to learn key critical information about what the doctor did and why. I want to know his rationale. I want to know what he was thinking. I want to know what the standard of care was in his own words, and whether or not he lived up to those standards. Okay, so now there's no judge there, there's no jury there, but there is a court stenographer there. Well, in this case, she's online recording all of my questions and all of the answers that the doctor gives. And the answers that the doctor gives represents his sworn testimony, and you should know that it carries the same exact weight as if he is testifying at the time of trial. Okay, so now this is an important tool that we use to learn information about what went on in this particular case. So is it ever appropriate for the defense attorney to raise an objection every single time I ask a question? And I say that, in my opinion, the answer is no. But there's a strategy for attorneys who try to do that. And what is their thinking? Their thinking tends to be, okay, let me distract the attorney as much as I can. Let me go ahead and try and distract him so much to the point that he doesn't remember the next question he needs to ask. Let me distract him to the point where he gets so confused about what questions he needs to ask the doctor, he's going to lose track and focus more on the infighting, focus more on the objections and the legal reasoning about why these questions are not appropriate. If the defense lawyer were to object to every single question that I asked, it will become obstructive. If the defense attorney were to do that, it would clearly create conflict, it would create distraction, and it would create lots of problems. So what do I mean? Doctor, isn't it true that on January 1, the patient came to you? Objection! Really? What's the objection? I'm asking a factual question. Now, we have to argue about whether or not the question is appropriate. And here's something else you should know. Even if the attorney objects to a question of mine, the doctor still has to answer the question. So what the attorney is doing is preserving his right to object when this case goes to trial if I ask the doctor the same exact question, which he'd be able to do anyway. Now, why is he doing this? He's doing this because he wants to cause me confusion, he wants to cause distraction, and he wants me to divert my attention from the real issues in this case. I may ultimately have to bust this deposition, which means I may have to end this deposition without me being able to properly question the doctor. And what does that mean? It means a couple of things. It means I'm going to have no choice but to ask the judge to intervene and basically go to the judge and say, Judge, this defense lawyer is prohibiting me, preventing me from asking questions. There's a clear pattern of obstruction here where the attorney is trying to prevent me from focusing on the questions I need to ask, and he's doing it improperly. So I ask you to, number one, bring the doctor back for a deposition, number two, to sanction and penalize the attorney for his actions, which he knows are improper. I will make a formal written request to the judge known as a motion, and I will include the actual transcript of all the times this attorney has objected to my questions. You know, after being in practice for 32 years, I find that the best attorneys tend to be the most experienced attorneys, the trial attorneys especially, who understand exactly what we are trying to do, we understand what they need to do, and it's appropriate to go ahead and make an objection if there's a legal basis to do so. But for every single question, that's totally out of line. For every single question, there's only one purpose for which the attorney would be doing that, and that's to obstruct the deposition, to get me off track, and it's simply not appropriate. So why do I share this information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases, these accident cases, and even these wrongful death cases here in New York. You know, I recognize you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit and are thinking of doing so, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a great day.